today is going to be Professor David Lyons of Boston University Law School. So a little bit of background. Professor Lyons did his PhD at Harvard, a dissertation that was later turned into the book Forms and Limits of Utilitarianism, a widely cited book that seems to be generally regarded as the decisive refutation of the traditional rule utilitarian view. After that, he worked at the Cornell Philosophy Department and Cornell Law for some number of years, where, despite what you might think, given that he signed off on my own dissertation, he oversaw such later luminaries as David Brink, David Kopp, John Simmons, Gerald Postima, and Sterling Harwood, who I learned online now has a radio show in San Jose, talking about, among other things, true crime stories and conspiracy theories. I also learned online that David Lyons shares a name with an author of thriller novels and a semi-famous Australian actor who had a run on ER. So in addition to these kinds of things, he's also written numerous books, including In the Interest of the Governed, a study in Bentham's philosophy of utility and law, Ethics and the Rule of Law, Moral Aspects of Legal Theory, Rights, Welfare, and Mill's Moral Theory, his recently published Confronting Injustice, Moral History and Political Theory, and he's lately been working on a book of history of race law in the US called The Color Line. He's written dozens of papers, including Ethical Relativism and the Problem of Incoherence, Rights, Claimants, and Beneficiaries, The New Indian Claims and Original Rights to Land, The Nature and Soundness of Contract and Coherence Arguments, and Rights, Welfare, and Mill's Moral Theory. And he has been for many years a champion of various equitable causes, including racial justice, anti-war causes, and the like. And so today he's going to be telling us about reparations for slavery and Jim Crow. Thank you all for coming.
Okay. In recent years, each House of Congress and several states have formally issued apologies for government support of slavery and, significantly, for continued racial subordination after slavery was abolished. In most cases, there was an addition to the apology to the effect that it may not be used as a basis for litigation. The apology and the qualification are both reasonable. Government was very much involved in the maintenance of slavery and in the continuation of racial subordination after slavery, in ways I'll mention as we proceed. It was understandable that the governments, state governments that issued the apologies and each House of Congress, they never issued a joint resolution. But we know how Congress works these days, or it doesn't. So these were recent actions. It was understandable that they should add that qualification because there has been litigation, not successful, but attempts to use the courts as a basis for extracting some kinds of reparations or compensation for things that have happened in the past, either from corporations that have existed over long periods of time, or chains of corporations, some having taken over previous ones, or the government. Sometimes for specific incidents, such as the destruction of the black community in Tulsa, Oklahoma, what I would characterize in more familiar terminology as a pogrom. Pogroms were familiar enough in America. That is, destruction, attacks on and destructions of black communities, which we know of more in association with attacks on and destructions of Jewish communities in Russia and Eastern Europe. The term, as far as I know, has never been applied in the United States, but it's certainly appropriate. Reparations have been issued by the United States, as well as formal apologies by the government. These are interesting. Reparations were issued to survivors of the internment of Japanese Americans during World War II. It happened about 40 years after the fact. Survivors of the Tuskegee syphilis study, if it can be called that, and an apology. I don't think any reparations were issued. An apology for the forcible takeover of Hawaii. Hawaii was taken over by the United States in 1898 during the period of the Spanish-American War, and I remember learning that it wasn't a Spanish colony. Hawaii was an independent country that the United States just took over, or that Americans, with the help of the U.S. Marines, took over, and then it was annexed by the United States. Now, these are appropriate, even though they go back to previous generations. Hawaii's case was issued, I think, on something like the 100th anniversary of the annexation of Hawaii. That apology was issued. And it's quite appropriate because you have a continuing government that has a long history of wrongs, and that's relevant here. But my interest, I'll explain what my interest is. I've written about reparations before, and I want, in part, to respond to an interesting criticism of a suggestion that I made. I have defended the idea of reparations for slavery and Jim Crowe, though even putting it that way is a little misleading. I'm concerned with the moral issue, not with the legal issue. I'm not a lawyer, despite my association with law schools. But I'm interested in the legal argument and the moral argument for doing something to repair what's a continuing wrong. Let me put it that way. I'll try to explain what that continuing wrong is. What I had suggested in a couple of previous articles was a program to create equal opportunity for children. It doesn't sound very much like a reparations program, which is exactly the comment that was made by Tommy Shelby quite fairly in a recent workshop. Creating equal opportunity, well, let me explain what I mean by equal opportunity is comparable life prospects for black and white children. And I'll explain the point of this later. But creating equal opportunity is you might say, an obligation of government in any case, and it's forward-looking, and it has no specific reference to wrongs done in the past. Whereas reparations, it's got to be backward-looking and has specific reference to wrongs done in the past. Even if they're continuing wrongs, but they're wrong. So it's reasonable to question whether that's a plausible reparations program. I thought about looking at the argument for reparations anew, and starting in 1865, when slavery was abolished. What was the argument? What would have been the argument then? And what would have been a fair and reasonable reparations program at the end of slavery for the former slaves? So that's one of the questions. And one of the reasons I thought of this, didn't just pop into my mind, was there was a proposal made by one of the so-called radical Republicans, Thaddeus Stevens, one of the leaders of the House of Representatives in this period, Civil War and post-Civil War period. he proposed in 1865 confiscation of 400 million acres of southern plantation lands, the largest 10% of the plantations, and that that land would be used for 4 purposes. Each former adult slave would get 40 acres. That would account for only 10% of the 400 million acres. The other 90% would go for 3 purposes: to compensate Union supporters for property losses they suffered during the Civil War, to pay for Civil War veterans' pensions, and to pay off the war debt. Nothing reparative about that. But I tend to think of the first purpose as sort of pushing in the direction of reparations, though it can be understood as more than that. In fact, the question I want to raise is, what rationales or what justifications could there be for these proposals? But in order to think about reparations concretely, that is more concretely than we usually do and that I have done, I want to look at slavery and then Jim Crow and their consequences more systematically and more closely, and think about what they involve and what a reasonable and fair reparations program would involve, which doesn't primarily involve money, I think. Okay. The argument for reparations, I should add, the reason I said that it's a little misleading to talk about reparations for slavery and Jim Crow, because slavery ended in 1865, so that's 150 years ago, roughly. Jim Crow supposedly ended in 1960s, at least. 1965 is a convenient date because 1965 is the date of the Voting Rights Act, the last major civil rights enactment in the United States. 3 major actions. Brown versus Board of Education in 1954, which declared that racial segregation in public schools was unconstitutional. That led to a series broadening judicial decisions. 1964, the first significant Civil Rights Act since 1875, which the Supreme Court in the 1880s eviscerated. And 1965 is the Voting Rights Act. And 64 and 65 actions are very important. And there have been a lot of changes made as a result of these. Not reparations. So just to anticipate, so you'll understand where I'm going, or you know this, there were no reparations at the end of the Civil War when slavery was ended. There were no reparations when Jim Crow was formally ended. There's a moral argument for both. My position is that the moral argument for 1965 is basically the same as the moral argument for 2015, because the fundamental problems haven't changed. We're talking primarily about the legacy of slavery and Jim Crow, what sometimes called misleadingly structural racism. I prefer to refer to them as entrenched inequities that cannot simply be eliminated by eliminating discrimination, but that result, that flow from slavery and Jim Crow and can be attached to government policies, among other things. Okay, what did slavery involve? I'll list some of the wrongs that slavery involved. Wrongful imprisonment, physical assault, sexual assault, coerced uncompensated labor, arbitrary and unwarranted punishments, torture, incapacitating punishments, deadly punishments, forcible separation of family members, Now, families weren't officially recognized, legally recognized among slaves, but family groups existed, and they were broken apart by sales and bequests and so on. Severe restrictions on intellectual development, on family development, on religious expression, oppressive, constant insecurity, and profoundly offensive imposition of white supremacist ideology. Everything is justified in terms of the inferiority of blacks and the superiority of whites. Now that's a short list of the set of wrongs for which reparations would have been appropriate. But what would they have involved? I think that in order for Thaddeus Stevens' proposal to become plausible, to have become, I should have said, Thaddeus Stevens' proposal was rejected the year after he issued it. So we never had one. There was not a great deal of interest in compensating ex-slaves. For a long time, of course, before abolition, the only people who were considered as needing to be compensated were the slave owners. Because after all, they lost the most valuable property that there was in the United States at the time. That was 4 million slaves, who were worth up to $1,200 a piece, via advance, or more. You multiply it out. What would have had to be added to Thaddeus Stevens' proposal to make it a reparations proposal? Here are some suggestions. First, what I'll call, for want of a better term, an expressive and informative program to explain why reparations are needed. The government is taking an action. It is providing property and services under such a program, and there needs to be an explanation of it. And part of the explanation is going to be, at least part of it, is going to be in terms of the wrongs done and the need for compensation. Okay. That's an essential part of it, to make sure it's a reparations program. What else? Distribution of land isn't enough. Experience showed that those who would have gotten land would not have had any security, because there were some, but very small numbers of former slaves who through one program or another did actually get land, though it was hard to hold on to for reasons I'll explain now. What they needed was access to credit, access to markets, and access to goods. Otherwise, it couldn't function effectively as independent economic units. And in fact, there was, in effect, a conspiracy within part of the white community to deny these things. And so many blacks who had land lost it. So that's the second addition. Third addition is enforcement of civil rights, including voting rights, and protection of the law against assault. Because there was a violent backlash in the South against the slaves, the former slaves, and their white supporters. Hundreds, if not thousands, of former slaves were murdered, and many of their white supporters. Larger numbers, more, were subjected to economic intimidation, to actual physical assaults, such as whippings and so on, especially those who seemed to be leaders in their communities or were economically successful. And this is a pattern that persisted. There were organized groups, many more than the Klan, that issued organized terror. During the 1870s, the U.S. Army, which occupied military districts in the South under the Reconstruction statutes, U.S. Army was effective in countering these terroristic groups. But 1877, there was an agreement made between the Democrats and the Republicans over the contested presidential election of 1876, the so-called Hayes-Tilden Agreement. And the Republican candidate was allowed to take the election on the understanding that federal troops would be withdrawn from the South. And they were. And that was basically the end of Reconstruction. And it was the beginning of the period in which the federal government simply averted its gaze from what was going on. And it was the beginning of the pathway to the establishment of Jim Crow. So what happened was that white supremacists regained control of the state governments and issued laws, enacted laws that were colorblind in our terms today. The federal courts would allow any kind of legislation that had the effect of depriving blacks of voting rights, provided that they didn't mention race. So they were colorblind. But the poll tax, for example, and other such rules, or making it very difficult for people to register, familiar tactics that we used and are now increasingly being used with voter ID laws and so on. It's not a coincidence. So about more than 90% of black voters got disenfranchised, and that entrenched the white supremacists in the state governments. And during this period also, in addition, I might mention, the result of these colorblind enactments was that many poor whites also were disfranchised, but that didn't bother a lot of the people who were in charge, because some of them had been allying themselves with the former slaves and forming effective political coalitions. That's a long history that goes back to the 17th century that has always led to preemptive strikes, so to speak, against black-white coalitions. An interesting history itself. During this period, one of the most notorious methods that was used to guarantee that disfranchisement would take place and that this new system would be constructed that was as close to slavery as possible was lynching. Now, this was not a completely new phenomenon, but it was very unusual for slaves to be killed except by their own masters, because if you killed a slave or you injured a slave, then you were responsible to compensate the master, not the slave, okay? The master, the valuable piece of property. So the masters could kill their slaves. And gradually, during the antebellum period, there were laws enacted in the South nominally to allow for the prosecution of even masters, owners, holders of slaves to be prosecuted for the malicious killing of slaves, but they were never enforced, as far as I know. Now, since African Americans were no longer anybody's property, they could be killed with impunity so long as the enforcement mechanisms were not going to enforce that part of the routine criminal law. We're not talking about enforcement of constitutional rights, we're just talking about rules against homicide, rules against assault, and so on. These are simply not enforced. I mean, that's characteristic of Jim Crow. So you had in 1865, with abolition, former slaves entered the free society without property, Many of them were illiterate. Many of them were traumatized because of what they had experienced. Many of them were separated from loved ones. Many of them were disabled by work or the punishments they had experienced. Many of them were without provisions. So what else should a reparations program involve? Well, many former slaves, most former slaves wanted to stay in the place they regarded as home, which was the South, and in agricultural work. And since they couldn't get land of their own, they either became hired help or tenant farmers, or by far the biggest class became sharecroppers, which meant that what they got at the end of the year was dependent upon the plantation owner's calculations. And they got mired into fraudulent calculations and indefinite debt. So what would have been needed in a reparations program, in addition to what I've mentioned, is specific services, literacy training. The Freedmen's Bureau provided some of this. Independent organizations provided some literacy training immediately after the war. But that couldn't continue indefinitely because of the new regime that was very unfavorable to that sort of thing. Provision of prosthetic devices, medical care for those who needed it because of either the physical or the mental trauma that they had experienced. I think that might cover that need. So, we didn't have any of those kinds of programs, except peripherally. Let me now characterize Jim Crowe. I use the term Jim Crowe rather than racial segregation because racial segregation sounds aseptic. That is, it sounds separation, but that's not characteristic of Jim Crowe. Characteristic of Jim Crowe was, first of all, I'm going to use many of the items that were on my previous list. Wrongful imprisonment. This took the form, that is, of the use of the courts to put blacks in prison when they weren't guilty. And convict leasing, a very widespread system in the South, where someone could be convicted of vagrancy, be subjected to fees to pay for the police arresting them, for the court time, for time in prison, which they could never pay, and that was translated into additional time in prison. And then the courts would make contracts with private employers. Usually it was private. The big steel corporations, for example, around Birmingham did a lot of this, but not just that. Mining also. The convicts would become slaves, essentially. There's a very interesting book called Slavery by Another Name, which is about that history. So convict leasing is one of the forms of wrongful imprisonment, but use of the prisons generally. Physical assault, sexual assault, including lynching, because the laws were not used, the official enforcement mechanisms were not used equally to protect blacks. Coerced, uncompensated labor, that is, convict leasing, and to some extent sharecropping. Arbitrary, unwarranted punishments, including torture, police abuse, executions, severe restrictions on intellectual development, no provision or inadequate provision for schools, or inferior schools, severe restrictions on jobs that would be open, on the development of skills and the possibility of careers. I mentioned pogroms, oppressive insecurity, and the profoundly offensive imposition of white supremacist ideology. Continuous. Constitutional rights were not enforced. There was exclusion from the political system, a lack of legal recourse in cases of wrongs done, and systematic violation of law by the law enforcement parties themselves. So what you had in the 1950s and 60s, and I won't go into this right now, but there's an interesting coincidence of time there with the development of the Cold War and the development of the Third World, so-called, as we call it, reforms in the United States. Culminating in '65. There was actually a Fair Housing Act of 1968, but it included no enforcement provisions. And 20 years later, when enforcement provisions were added, there was no funding for them by Congress. So you really haven't had, except on the basis of independent actors outside of the government, you had no enforcement of fair housing. So the segregation, housing segregation, is hardly touched. And what we have, of course, is de facto residential and school segregation throughout the United States. Hardly affected by the changes that occurred in the 1950s and 1960s. But there were some significant changes. For the first time in the United States, or in the going back into the colonial period, the official rejection of racist ideology, the official rejection of racial discrimination, and some reforms against violent resistance. Many, many lives were lost during the Civil Rights Movement. Black and white, mostly black, but they were white. However, the vote was restored, and there has been increasing job opportunities, educational opportunities, and career opportunities, but no reparations. Eliminating discrimination doesn't provide reparations. Although at the time, of course, there were many survivors of Jim Crowe who had valid claims for reparations, just as there were many survivors of slavery who in 1865 would have had valid claims for reparations. And there were culpable parties, individuals as well as institutions, who are arguably morally liable. In the first instance, in my view, the government. Why do I speak of a legacy of slavery and Jim Crowe? Well, it's represented in part, perhaps most dramatically, by the existence of black communities, so-called black urban ghetto. Now, one of the things that was possible to happen under Jim Crowe, which happened on a much, much smaller scale during slavery among free blacks, was the development of the black middle class. So you had black communities with businesses and so on. You had black clergy, you had a black church, you had black insurance companies, you had black banks, and so on during Jim Crowe. Nevertheless, families did not acquire resources at anything like the rate of white families in the United States during Jim Crowe or after. And that was because there were certain policies that we know, perhaps, you may have heard of: redlining, blockbusting, and other such policies that the government itself endorsed. That is redlining, not blockbusting. Blockbusting was a realtor's practice. And I can explain that for those of you who don't know about that. But the single most important source or basis of wealth for families in the United States is family home. The family home is the basis for not only wealth that can be transferred to the next generation, but also something against which loans can be made so people can start businesses and can go to colleges and things like that. Without the accumulation of that kind of wealth, without those kinds of resources, the acquisition of skills, education, and further wealth is held back. And that's characteristic of the history of the black community. So if you look at statistics, which are very easy to find, about family resources for blacks and whites, you find the differences are enormous, much greater than the differences in incomes. And even with the relative equalization of incomes, which is still significantly different, the wealth gap, as it's called, remains very substantial. That's one of the entrenched inequalities. Poorer housing, poorer education, lower income, less work, higher unemployment rates, lower wages, reduced family resources. So patterns that flow from past policies, some of them adopted by or enforced by the government, some of them unchecked by the government, that have resulted in these kinds of gaps that are not touched. That's why in 1965, reparations would have been appropriate. And insofar as those conditions haven't changed, reparations today could still be appropriate. So, I looked at the idea of reparations from the standpoint of equal opportunity. Let me explain why I did that without thinking clearly, without developing a clear argument. But this was my idea. The idea of equal opportunity is sort of an American idea. Who's going to argue against equal opportunity? But if you really wanted to create equal opportunity for a black child and a white child, then you would have to change the conditions of the black child's life. And that would mean that their parents would have to be treated comparably. That is, there couldn't be unequal wages. There couldn't be unequal job opportunities. There couldn't be unequal schooling. There couldn't be unequal housing. There couldn't be unequal health care. Otherwise, you wouldn't have comparable life prospects. So you had to eliminate the disparities between blacks and whites more generally, and the entrenched inequities in order to create equal opportunity. That was the general idea. That was the term idea. Now, the question is whether this is nevertheless too forward-looking. Well, I'm not sure how to characterize it. I mentioned the Thaddeus Stevens proposal. Seems to me that the Thaddeus Stevens proposal, if it was supplemented suitably, it would have had at least 3 or perhaps 4 rationales, not purely reparative, not purely backward-looking. If it had been supplemented, then it could have been part of a reparations program. But it could also be justified, as the idea of Reconstruction itself was, on the basis of promoting economic independence of former slaves and the democratic society in the South, which hadn't existed before. Society in which the state governments and the local governments were actually under the control of the electorate. Because in order for there to be political independence, there has to be economic independence. So that element would be, that is, that rationale is forward-looking to promote democratic society that is more egalitarian than existed before. But the program that Thaddeus Stevens had proposed would serve other needs besides reparative. It would have benefited poor whites. It would have benefited veterans. It would have benefited the country as a whole. So it would be backward-looking, forward-looking, and be dedicated to political feasibility. It wasn't feasible enough. And that's a problem about reparations programs, to make them feasible enough. So apply that idea to the idea of a reparations program for 1965 or 2014 or 2015. The idea of creating equal opportunity for black children and white children, I think, has similar multiple rationales. You want to make the future better? It's forward-looking. You want, however, to explain the need for the changes that will make the future better for black kids in terms of the legacy of slavery and Jim Crow. That is the need for such a program, which would be enormously massive to eliminate the entrenched inequities. So it would be backward-looking, but also forward-looking. And the idea of equal opportunity would be conceived of as making it politically feasible. However, the problem is, and this is ironic, and I'll explain why it's ironic, it's utopia. And the reason it's ironic is this. At a certain point in revisiting the idea of reparations, I realized, hey, I'm doing non-ideal theory. Rawls, I think, is the one who introduced the distinction between ideal and non-ideal theory. Ideal theory is supposed to, well, it's the theory of justice. What would a just society be like? What kind of principles would it be regulated by? Non-ideal theory says, how do you get from here to there? Or how do you address injustices more generally? So I realized, hey, this is non-ideal theory. And I had a revelation. That is, it was like bourgeois gentilhomme in Moliere's play, realizing he had been speaking prose all his life. The problem, however, as I said, is this non-ideal theory that's utopian. I don't know how to design or conceive of a reparations program that would be politically feasible in the United States. that wouldn't give up so much that it was no longer effective. And that's the sense in which, at least, I can't imagine the United States government or any state government embarking on such a program. I mean, think of the attacks on the Affordable Care Act. Think of the difficulty of extending unemployment insurance. Think of the difficulty of reining in the banks trying to prevent another recession like that began in 2008. It's hard to imagine the government engaging on such a thing. So that's the irony of it. And I'll stop here.